Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. Tonight, I'm joined with our co-host, Jane Faherty, who is the director of the Jewish Community Center JumpStart program. She's also a special education advocate. And we have one of our returning champions, Allie Grafman, who's also a special education advocate from ABC Advocacy. Jane and Allie will offer some introductory remarks. We are continuing, Jane and I are continuing, this is our fourth year of doing these webinars. We're part of a community of concerned parents and professionals. We're still learning how to connect with one another. And we've been moderating a series of webinars to address these ongoing concerns in these unprecedented times that are affecting the education of our children with special needs. We are here to address social, emotional, educational impact on your child's educational journey. Tonight we're having a roundtable, so we have quite a few questions that already came in prior to tonight's webinar. Allie, Jane, and I will try to get to all of them. We have posted some resources in the chat section of the webinar. So there's some contact information for myself, Jane, and Allie. There are some resources based upon some of the questions that we received. For those who are unfamiliar, this webinar is being recorded and will be available on YouTube shortly after we conclude tonight's webinar. I do offer a disclaimer. The webinar is being recorded. A copy will be provided to each person who is registered. The information in this webinar does not constitute specific legal, educational, or professional advice regarding your child or your circumstances and should not be relied upon as such. The webinar does not establish an attorney-client relationship with myself, attorney Lawrence Berliner, or a professional relationship with Jane Faherty, the Stamford Jewish Community Center, JumpStart, or Allie Grafman of ABC Advocacy. By signing up, you've agreed to receive emails about future webinars and events from the Stamford Jewish Community Center and the Law Office of Lawrence Berliner, LLC. Please note that Zoom is a third-party provider and not an agent or associated with the Law Office of Lawrence Berliner, the Stamford JCC, or Allie Grafman, ABC Advocacy. The information provided is based upon Connecticut state law and policies and federal law that covers all 50 states. If you're watching this webinar from another state, or in some cases, another country, you need to consult the laws and the policies and the resources that are in effect in your state or jurisdiction. And we have had several people register from other countries, and we welcome you, and we welcome those who've registered from other states as well. So without further ado, we're going to be discussing tonight additional discussion on basic rights, annual review PPT meetings as we're approaching the end of the school year, ESY or extended school year programming, IEP issues that have come up in the questions, occasionally a 504 plan question, and next steps. So without further ado, Jane, how are you and what's new?
Hi, good evening. I'm Lawrence and happy spring. Today is the first day of spring for 2024. So I can't believe it is 4 years, Lawrence, that we've been doing this, probably pretty much to the week that we launched our first webinar virtually. So it's nice to be back. It is the silly season. We're not only looking back at past performance over the year, but a lot of families are concerned or have trepidation for how this year is going to close and what preparation should be made already for the next school year. So I know that this is a very anxious time for families, but that's why we're here this evening. So we welcome you all. Allie, it is really lovely to have you back and join us. And it's going to be nice to brainstorm together on the variety of questions that we've had this evening. So hello, Allie.
Thank you, Jane, and thank you, Lawrence. Welcome, everybody, and thank you for joining us. Just a brief kind of summary of my background. I came from a public school background where I was a special ed teacher and then became a special education administrator. And since retirement, I've been doing advocacy now for about 11 years. Can't believe it, time flies. I love what I'm doing. It's great to do these seminars, and our whole purpose for these seminars is to empower our families. And that's our goal, to have parents, community leaders, teachers, administrators really come together collaboratively and look at the child's needs. So hopefully we will get to all the questions tonight, but we appreciate your attendance and am really excited to be here. Thank you.
And one additional housekeeping note, if you have a question during tonight's webinar, we ask that you place it in the Q&A feature at the bottom of the computer screen and not in the chat section. The chat section is being recorded, the Q&A is not. So in an effort to preserve confidentiality or privacy, we ask that you use the Q&A feature. So without further ado, why don't we dive into tonight's topic and start with some of the questions and concerns that we have received over the past few weeks.
So one of the things I think is fascinating tonight, I'm an advocate. So I began advocating 10 years ago for the JumpStart children that I transitioned into the public school. I enjoyed it so much. I then went on to do a formal qualification or certification called the Seat 2 training through the Council of Parents, Advocates and Attorneys, which was a really great organization to show up my technical knowledge and expertise on a federal level. And then through continued professional development, I understand the Connecticut state guidelines and laws surrounding special education. So I think one of the interesting questions that we got today, we've not really been asked this before. Somebody asked to know, what can I expect from having an advocate at a meeting versus a lawyer? And I would like, Lawrence, for you to first explain the difference in terms of what in the state of Connecticut, because this is Connecticut Pacific, what a lawyer can do versus an advocate with your many years of experience.
Yeah, we thank you, whoever asked that question. It gave us a lot to think about in preparing for tonight's webinar. I'm an attorney. I'm licensed to practice law here in Connecticut. I've gone to law school. I'm involved with continuing legal education. One of the things lawyers do is we go to court. We file administrative complaints. We file judicial complaints in an effort to pursue rights that are guaranteed under state or federal law. In the context of special education, children with disabilities are entitled to a free, appropriate public education. That's a legal standard. And whether they have a 504 plan, they're entitled to a free, appropriate public education. If they have an IEP, an individual education plan, they're entitled to a free, appropriate public education. Those terms are defined differently by the federal special ed law and Section 504. But what both laws have are procedural safeguards. The procedural safeguards are the family and the child's rights. And those rights are enforceable rights. They can be enforced administratively, they can be enforced judicially, and in some cases they can be enforced by civil rights complaints filed with the United States Department of Education, Office of Civil Rights, and occasionally the United States Department of Justice, depending on which federal civil rights law we're talking about. We have special ed laws, we have anti-discrimination laws, and many other laws, and this is all based upon either state or federal law. So what do? I articulate my client's concerns, and I will advocate for those concerns, and if necessary, litigate those concerns. These days, most of my practice involves negotiations rather than litigation, and that's a positive. But there are cases that end up going to due process hearings. There are cases that end up going to of state or federal court. And that's one thing an attorney does that an advocate doesn't. That's the litigation piece. But a lot of what I do is parallel to what an advocate does. So we'll let the two advocates speak on what they do.
So Allie, what do you do as an advocate? Because the nice thing about your experience is you've been on both sides of the table. You have been an educator, you've been an administrator, and now you are an advocate. So describe what you do versus what an attorney would do.
So my perspective of everything is when I became an advocate after retirement, one of my colleagues said to me, oh, now you're on the other side of the table, the dark side. Okay. And I'm going like, what's going on? I never look at it that way. We are all on the same side of the table. We are all advocating for the child or for the student. So that's my role, to advocate. What does advocate mean? To me, it means support. And that, I think that's the difference. I support my families through the IEP process, through attending meetings, through preparing my families for a PPT, by going over the IEP or the 504 plan, and making sure that the program and the components of the program are appropriate and the goals and objectives are measurable. So I kind of fine tune with the family all of the areas that need to be addressed. An attorney supports the family, but also works to represent the family, advises the family. I don't represent, I don't talk for the parents or the student. I support you. And that's the difference. Like in a negotiation, an attorney will talk attorney to attorney. I don't talk to the attorney unless it's at a PPT. So everything that I do is in support of the family. And I hope that clarifies it. But, you know, the roles are similar except for the legality issues. Like as an advocate, I don't go to due process. An advocate can go to mediation, which is a non-legal situation, but it is an attorney can also go to a mediation. So there are overlaps in our roles, but usually an advocate has the experience of really getting into the IEP and the PPT process and working with the school, the parents, and outside resources to work together to make sure that the program is appropriate for the child.
The thing that I enjoy as an advocate, just like Allie, having experience as an educator within the field of special education and working with children as well as families, I think that as an advocate, you come to the table with an understanding not only of the child and how a child's needs could be specifically and individually met, but you also potentially come with an understanding as to how to build collaboration and communication amongst the team. As quite often families, that the communication is broken down. The families either don't feel that their districts are listening to them, that they understand their child, or there's a miscommunication in terms of data collection and how to support a family to review the data and to understand the information. So a lot of what I know that I do as an advocate is to give the parents the confidence and the understanding as to how to eventually do this independently on their own, to give them the expertise to become their own advocates, to find their own voice and to articulate and share that with the team members, remembering that they are the most important person around the table. Versus obviously an attorney has other areas that they can realm into, the legals, the due process, which isn't, as Ali said, anything that we do. But the follow-up question to this we got asked today, Lawrence, you might have an answer to this as well as you, Ali. Is there financial support or pro bono opportunities for representation for families who could not afford either an advocate or an attorney in the state of Connecticut?
Another good question, and we are fortunate in Connecticut to have several organizations. I think we've placed their contact information in the chat. In no order of priority, we have the Special Education Legal Fund, in Connecticut, and they have grants available for advocates and attorneys if you meet their income asset requirements. It's unfortunately the demand exceeds the supply, but that's often the case. We also have the Connecticut Parent Advocacy Center, and I might add each state has a Parent Advocacy Center. It's a resource for parents. In Connecticut, they do a lot more. They have a toll-free number where you can get some initial advice and information. We also have an organization called FAVOR, F-A-V-O-R, that provides some limited advocacy. And there are other civil rights organizations like the Disability Rights Connecticut. Each state has a protection and advocacy system. In Connecticut, it's called Disability Rights Connecticut. The national organization called the National Disability Rights Network, NRDN, has a state-by-state directory of the protection and advocacy offices. They're all different. They have different, missions and different amount of resources. And then in some cases, the legal aid organizations serving your community might have availability. In Connecticut, we have a lawyer referral service operated by the local and the state bar association. And it's sort of hit or miss if you can find those resources out there. They're not evenly distributed in Connecticut, and I'm sure they're not evenly distributed in the other 49 states. So the important thing is, and I might also add, the State Department of Education website, ct.gov, and the United States Department of Education, ed.gov. There's a lot of resources out there that parents can tap into online. And then as far as the Connecticut-based pro bono or low-cost resources, I've given you a partial list. I don't know if Jane and Allie have more than what my short list consists of.
I'm not sure if you mentioned the Special Education Legal Fund. There's an organization you can apply to, which you may or may not be eligible to receive support, some financial support from them. So that there are some organizations, there is a list, as Lawrence mentioned. It is the time of year, it's spring, as I said today, the first day of spring, and it's a time of year where families might be looking to move and relocate within the state or into our state. And this was a question we received ahead of time from a family. What testing should be done when a child moves from a different state with an IEP and registers school during the summertime? And that's a question to either you, Allie, or you, Lawrence.
Go ahead,
Allie. Go ahead.
I think the first step is to have an informal meeting with a representative in the school or the school district that your child will be going to familiarize yourself with their programs and schools and so forth, and ask them if there should be testing, because every student has a different, I guess, a profile of testing. So if testing wasn't comprehensive or sufficient enough from your last state, the school can kind of fill you in on what testing needs to be done. However, that being said, there would be, if your child is already in special education, there would need to be a PPT over the summer in order to decide what testing. So that first step of meeting informally will be able to drive you to the next question. Do you need a PPT over the summer to look at testing if you wanted the school to do the testing? If you yourself as an individual wanted to do your own independent or private testing, that's something that's your decision. But I would first go to the school and find out what they feel is necessary. The one exception that I would say to all of this would be if your child has a physical handicap or if there are safety issues. if your child is in elementary or even middle school and there will be playground issues, you may want to ask the school to do an environmental safety assessment before your child gets into the school. To me, safety is first. So you don't want to have your child go to school on the first day and enter into a playground that's not safe. So that safety assessment can be done over the summer. But again, that's a question to ask your school district.
Just to expand upon Allie's comments, you want to share the last IEP, you want to share any public school evaluations, any private evaluations. And most important, as parents, you want to share your concerns. How does your child learn? Are there likes or dislikes? Are there sensory issues? Are there, Allie talked about, safety issues. You want to have as a parent, you want to have an opportunity to at least see the building, see if there are any physical barriers or other kinds of barriers to your child receiving that free, appropriate public education. Connecticut, we call it a PPT meeting. New York, they call it CSE meetings. In other states, they call them IEP meetings. Whatever you call it, these are the meetings to review the IEP, to develop an IEP, to discuss the need for any testing, if any, especially if your testing is current, meaning less than 3 years old. Why do we need to do more testing? That's a question, not a statement. And sometimes the testing is comprehensive and it gives the new district enough information, and sometimes the testing is not, and the school district said, we need to do this test or that test to have a better or a more rounded picture of the child's strengths and weaknesses. So whenever possible, collaborate, cooperate with the district, and that way your child will receive that free, appropriate public education.
We've had a lot of questions today about extended school year ESY, and questions. This one particular question was how best to make a case for ESY if your child doesn't typically fit the mold or they've been declined ESY, but you feel that they need they still need that skill development to be retained over the summer months. So any suggestions on ESY if it is declined? And I think that there's a misunderstanding as to exactly what ESY is. And it does vary a lot. The shape and form, the number of weeks and the days and the hours varies from district to district. So you also be mindful if you're talking to a friend that lives in a different school district, their ESY might present quite differently to your own. They are not apples for apples.
So the ESY is extending the IEP into the summer months after the end of the regular school year. In Connecticut, I typically hear the number 4 days per week, 4 hours per day, 4 weeks. There are exceptions to that, but that's what I typically hear. So that means you may be having services for the month of July and not the month of August. That could be a concern or not. But in order to determine the need for ESY in Connecticut, the school districts look at what's called recoupment and regression. And the best way to look at recoupment and regression are long holiday weekends, Christmas vacation. We have a vacation week later later in April. How does your child return to school? Is that Monday morning, or if it's a long weekend, Tuesday morning, a nightmare? Have they spent a long weekend without structure, support, education? Have they spent a week, 10 days not being in school? What does that look like? Because the recoupment regression analysis looks at, is your child regressing when they're not in school? And that could be summer or the other school vacations during the school year. And are they spending an inordinate amount of time recouping those skills? So while children may start on the first day of school, whenever that is, late August, September, for a child with an IEP, their first day of school might be the beginning of October because they're still recouping those lost skills for the first month or so. So what the ESY is supposed to do is support your child over the summer. In Connecticut, many school districts will say, we don't have to do anything other than maintain skills. The free appropriate public education standard applies to the summer as well as the regular school year. So school districts often do not want to promote progress over the summer, but just maintain the gains that were required during the previous school year. There's no law preventing a school district from providing more services to ensure active learning from where we left off at the last day of the regular school year and over the summer. So I don't know if
Just
Jane,
to add a bit to that, Lawrence, just to add a little bit to that, I've been confronted with ESY issues very frequently, and this is the time of year where you get to the ESY question or issue. I really like to look at it very objectively, looking at data. So what I do with my families is really kind of chart out, like at the beginning of the school year, what are the current levels of performance in each area of the child's deficit? So if it's reading, where did the child come in? What reading data do you have that you can that you can quantify? And then from there, go to, okay, like long vacations, like, December break. Was there any testing done during that time? And then weekends, especially long weekends, Thanksgiving holiday, quantify the information, whether you use testing data, you can use student performance, classroom worksheets, whatever, to quantify your data to show that there is regression, if there is regression. And that's really the objective way to do it, to look at the weekends, long weekends, vacations, the beginning of the school year before the student came, like at the end of last year into the beginning of this year. What were the scores? Whatever data you have. Now, to prepare for the following year, you really need to ensure on the IEP that data is taken. And that's part of the problem, that many schools don't have the data, but you can ask for that and make sure that it is on the IEP, that data will be taken long weekends, before vacations and so forth. So you have some quantifiable evidence. The other prong to ESY is the, I guess, what I would call the extent of the disability. So if you have a child that is extremely complex and is very much in need of consistent work throughout the summer, because without that, there would be regression, then you also have a case to request ESY. So again, it's the regression formula, and it's also the existence of a complex disability situation that your child may have. The two of those indicators are really what the PPT looks at. If the PPT rejected ESY, I would ask for the data. What data do you have to support the rejection? Because their lack of data is just as indicative as not of having data. So if they don't have data to support it, how can they make that claim? So that's one way that we look at ESY.
And the data might not just be based upon grades or traditional grades. The data might also be based upon school refusal. If you've now stabilized your child, they're now in a good rhythm, they're now comfortable in that learning space, you could argue, and the data might support, that if they were absent from that environment for a prolonged period of time over the summer, that's going to make it even more difficult for them to transition back in. So the data doesn't just have to be based upon academic performance, it can also be based upon their social, emotional performance and ability to maintain attendance on a regular basis too, because that can also be important if they are removed or unable to access that environment for a prolonged period. The re-entry can also be difficult. So you can use that as an argument. We did have a suggestion, or can ESY be granted as compensatory hours due to no therapy during the school year? And the answer is ESY is not compensatory education. ESY is an extended school year. So there is a difference between compensatory education. I don't know if Lawrence or Allie you'd like to address compensation. That is something that's been a hot topic. It always has been in special education, but particularly since 2020 and COVID, and even more so with the lack of educational resources, teachers, therapeutic specialists within districts. This topic of compensatory hours of education has come up more and more often. 2024 is no exception. In fact, it's probably getting worse. So what recommendations do you have for families who are at this point in the year that have reviewed their child's IEP and are taking note of hours that they might not have received in related services and or indeed special education?
Lawrence, you want to start?
Sure. Compensatory education services is an equitable remedy. It's to make up for lost time. So if an IEP has, say, 10 hours per week written in for direct instruction, related services, and this child is only receiving 5 of those hours, then 5 hours per week of lost services should be made up in the form of compensatory education services. And that can be direct instruction from a teacher, speech and language services, occupational therapy, physical therapy, counseling services, whatever the category of services. And I think what Jane was alluding to, sometimes there are districts that are having trouble with staffing. So the IEP calls for a certain amount of hours per week by a certified staff, say a special ed teacher, but what happens when the teacher leaves mid-year and the teacher's not there? So you look at the IEP, you calculate how many hours have been provided, how many hours haven't been provided, and in effect, you're creating a bank of hours. That's the compensatory services. And you make a request of the school district to make up the lost or missing hours that were specified in the IEP. How, when, and where to use those hours is subject to discussion with the school administration. I had a case many years ago where the school district, quote, forgot to hire a special ed teacher for them. And so the student did not receive approximately 20 hours per week for the month of September and October. We added up the hours and had a bank of hours, and that family wanted to use those hours over the summer. It wasn't ESY, they had a program in mind, and we used those hours for the program. So how you use those hours, when to use those hours, that's subject to discussion. Sometimes we want to extend the school day. Sometimes we want to use those hours over the summer. Sometimes we want to use those hours for private, if the school doesn't have school staff, sometimes we can use those hours for private providers. So there's not a one size fits all solution when compensatory service hours are being requested.
This is similar but slightly different. How to document when a school calls a parent to pick a child up early from school due to behavioral issues, or at this time of year, if a school suggests that your child shouldn't attend a field trip. That's also something that is happening fairly often. Any advice for documenting that and what steps a parent should take in those scenarios?
My understanding is that most students are discharged from school or leave early from the health office or the nurse's office. But definitely you would need to ask the school who would be in charge of documenting this, because it has to be on their attendance record. That is the responsibility of the school to document it. You as a parent or guardian need to document it as well, so you have your own list, but it also is incumbent upon the school to document when a child leaves early for whatever reason. And I would ask whatever office is responsible, whether it's the health department or guidance or whatever, to document the reason as well, the time, the day, the date, and the reason for leaving early. So you have a running record of that. As far as school trips, that is definitely a discrimination legal issue, and I'm going to turn that over to you, Lawrence.
Well, just before we get to that, if the school is not taking Allie's suggestion and documenting it, there's nothing preventing the parent from sending an email. I picked up my, child at 12:40 today because you told me they were sick or something like that. So there's nothing preventing a parent from sending an email that documents their understanding of the reason there's an early dismissal. What the special ed law, the Americans with Disabilities Act, and Section 504, another Civil Rights Act, all have in mind is no discrimination, no exclusion based upon a disability. So I've had many situations, and I'm sure Allie and Jane have as well. There's a field trip or some special activity, and the child with an IEP or a 504 plan is not allowed to attend because of fill in the blank reason, any number of reasons. Well, the federal law requires equal access not only to education, but extracurricular activities. So whether it's sports, whether it's field trips, whatever the activity is, unless there's a very compelling reason, probably bordering on a safety reason, the school has an obligation to make sure the child has equal access to the activity. Now, sometimes we have physical barriers, like the school bus is not accessible to a child who uses a wheelchair. Well, then get a van or small bus that is accessible, and you travel with the larger bus to the activity. Exclusion based upon a disability is illegal. It's enforced through civil rights complaints filed with the U.S. Department of Justice in some cases, if it's an ADA violation, American Disabilities Act, or the U.S. Department of Education if it's a Section 504 violation as well. So those are the civil rights enforcement agencies. If this is impacting a child's right to a free, appropriate public education, then that becomes a special education issue. So whether it's the federal special ed law, the Americans with Disabilities Act, the Office of Civil Rights Enforcement for Section 504, all of those are avenues to enforce rights to be free of discrimination based upon a disability.
This is an interesting question, and this goes back to what is mastery and is something truly mastered if it isn't generalized across all settings. So a parent asks, for a child with significant intellectual disabilities and autism, is it reasonable for goals to be mastered with adult support?
Well, my take on this, the last phrase, with adult support, the goal of education is to prepare children with and without disabilities for life after they complete their education, whether it's after the traditional 4 years of high school, where they graduate with a diploma, regular education diploma, or in the case of students with IEPs, the school in Connecticut, the school year they turn 21 or 22 or sooner. If we are promoting mastery with adult support, we're not promoting independence, we're promoting dependence. And the goal for all students, but especially those with IEPs, is to arrive at the finish line, meaning we have graduated or aged out of special education with a skill set that will take us into post-secondary education, hopefully competitive employment, and if necessary, independent living. So we have the skills to further our education if we're going off to college, vocational training programs, wherever we're going. We have the skill set to work in a chosen place of employment, at a job, a career that is within what your interests and preferences. And you have the skills necessary to live independently in your community. You take the bus, you have money management skills, whatever safety issues are that make sure that you are able to be successful in your community, however that's defined. So with adult support, maybe for a young child that's necessary, but there should be a point in time the adult support should be faded back and eventually eliminated to ensure that the child or the student is achieving the necessary independence once they graduate or age out of special education.
Just to add a little bit to that, the goal, as you probably know, is the umbrella area, like, you know, what the overarching goal is. Every goal on an IEP has objectives, or they should have objectives. The objectives can always be broken down into incremental steps. And that's really, you know, where we have to look at those objectives. If the same objectives get written on an IEP over and over again with support, the school is not breaking those steps down to discrete steps in order for the student to be able to achieve it independently. So take any one of those objectives. If it can't be reached without support, what are the discrete steps can be achieved by that child independently? Then you go from there and build on to those steps going forward. So eventually you reach a level of independence. So that's kind of where, you know, we work as an advocate to break down those objectives. One more dimension in talking about this is not just about the support, but the generalization of skills. And I see this over and over again with IEPs, that the child can achieve it independently in a very structured, you know, secure setting in a resource room with the guidance, with the school social worker or with the speech and language therapist. The child can achieve that goal independently. However, when the child steps out of that resource room, can the child generalize that goal independently in a variety of settings within the school, including the classroom, on the playground, in the lunchroom, in PE, and so forth? So once the child does achieve that goal independently in a resource room, now the charge is to generalize that skill. So doesn't end in the resource room, it ends in general education. That's, you know, really the way to look at those goals and objectives.
And that answers another question we also received is, what if the school says goals are mastered, but the parents disagree? Again, this goes back to documentation. If the school is saying that your child has mastered something in a school setting, to Allie's point, what environment was it within that school setting? And you can provide data and documentation yourself of that child functioning in the community, in their home setting, and with videos, with photos, with documentation to show what they have been able to do independently. They say it's numeracy, literacy work. You can take that in to demonstrate that when the child didn't have the same intense structured support in the school setting as out in the community, in the home setting, it isn't mastered until they can do it consistently across multiple environments. So if a school says that it's mastered, but you disagree, and you can prove that you have documentation evidence to show the child has not mastered that skill, you can take that to the PPT as well to show that it's something, an area that they still need to work on and have that continued support to master.
And just to add to that, you need the data. What is the data that the school has that demonstrates mastery? If you look at IEPs, sometimes it's 80% is considered mastery. Sometimes it's a lesser percentage. I think Jane just mentioned, you know, what you see at home. I had a client who videotaped their child reading to the grandparents. Forget us as the parents. We did this, you know, we took a video of reading to the grandparents, and the grandparents could not believe how limited the child's reading skills were, yet the school was reporting satisfactory or mastery of progress. And that's the generalization of skills. What I usually say, the purpose of education is not to make a student a good student at school, but to make them a good student in the school of life, because this is the learning laboratory. This is the training ground that takes you from elementary school to middle school to high school, to life after high school. And we as a society want to have the next generation ready to, able and willing to take on the responsibilities of, being productive members of our society, wherever that should occur. And without the skills to further your education, to become competitively employed, and to live independently, we're fostering dependence and not independence.
Now, evaluations, as we know, are the most important tool to really understand the needs of a child and how to develop an individual educational plan. We had a question: what is the best strategy to get a school district to pay for an independent educational evaluation? This is a topic that often comes up.
Well, it starts with the evaluation, and it continues if a parent disagrees with the evaluation. It's under-inclusive, they're writing about a different child other than my own, whatever the area of disagreement is, and the parent will request a publicly funded independent evaluation. It could be a psychological, speech and language, occupational therapy, physical therapy, on and on, assistive technology, whatever the area of disagreement is. The school districts have two choices. They can say yes, or they can say no. If they say yes, that means they will pay for the evaluation with a private evaluator, typically of the parent's choice. The schools can suggest, but not compel, a private evaluator. Sometimes parents know who they would like to use. Sometimes the parents don't know, where these evaluators are located, and the school might provide a list. If the school says no, then they have to file for a due process hearing to defend their evaluations. And there are some districts that work collaboratively with parents in trying to get that independent evaluator. Sometimes it's a mutually agreed upon independent evaluator. And there are other districts that routinely file requests for due process hearings. So it's very important that you understand your rights. In Connecticut, there is a Department of Education guidelines on independent evaluations available on the State Department of Education website, ct.gov, that explains rights to independent evaluations. And if you're caught up with a request for a due process hearing, it's advisable to consult an attorney, because these are formal trial-like legal proceedings. Sometimes the school district will proceed with the independent the due process hearing. Sometimes they might offer to go to mediation and find a third-party mediator to help develop a solution. But if the request is denied, it's always advisable to confer with an attorney if at all possible.
I have a question that's hard to answer, but I'm going to ask it anyway. It was submitted beforehand. A child that has ADHD, what would be best for them, a 504 or an IEP?
That's a good question. And it's really hard to answer without knowing the specific child, because there are many students that do fine with a 504. But some students with ADD or ADHD need an IEP. So how do you discriminate, and how do you figure that one out? The way that I look at it is, if your child with ADD or ADHD needs services, in other words, if your child cannot just function adequately or above in the classroom with the accommodations provided that a 504 can give you, then you really need to look at special education, because in special education, the child is able to get services. By that, I mean explicit services from either the speech teacher or the special ed teacher or the social worker, whatever the area of difficulty is. So let's take an example where if your child has executive functioning problems, like many ADD students have, and your child can't get all his work done on time, or is so disorganized that doesn't even know what the work is, then perhaps the accommodations alone will not really support the child sufficiently. It seems like in that situation, the child needs a special education teacher to work with the student one-on-one for executive functioning skills. So again, go back to, it depends upon your child's needs, and look at the accommodations and see if that's not working, then the child needs more support in the way of explicit services.
And we did have a question, what's the difference between an IEP and a 504 plan? And the 504 plan, as Allie mentioned, is about accommodations. Examples could be extra time, alternate test setting. You have a child who might have a physical limitation. They get to use the teacher-only elevator to get from the first to the second floor classes. There are no goals, there are no objectives, there's no reporting data. It's either the 504 plan is working or it's not. With the IEP, what Allie was talking about, with the services, that's direct instruction with goals and objectives. That's measurable. There's data to report satisfactory progress, mastery, or no progress, as the case may be. How a 504 plan and an IEP are enforced legally, they both have procedural safeguards, but how those procedural safeguards sort out is different. There's a mandatory administrative hearing for an IEP if there's a dispute. It's called a due process hearing. For 504 plans, there are hearings available, or people can bypass the administrative hearing, go directly into federal court. With an IEP, you have to first exhaust the administrative hearing called the due process hearing. So there's more accountability, there's more reviewability, there are more rights with a IEP than with a 504 plan. I don't make people have IEPs, I don't make people have 504 plan. It's based upon the student's individual and unique needs. Sometimes with a little extra time on a test, an alternate test setting, that's all the student needs to demonstrate their ability rather than their disability. Sometimes that's not enough, and we need a lot more in the form of direct instruction, IEP goals and objectives.
So I get asked this a lot. How do I get my child an out-of-district placement or relocated into a school that specializes in their needs? I think that where we live, sometimes there aren't always that many options, and there aren't that many schools that necessarily have the specialty that your child might need, and there's costs involved with that. So it's not a straightforward answer. It's very complicated. So I'm going to start with Lawrence or Allie, whoever would like to answer the out-of-district placement and how do we go about getting that for a child.
Lawrence, I guess.
Back to the free appropriate public education. Free is without direct cost to a parent. Public and education is what a school district provides. It's the word appropriate. It's not the dictionary definition of appropriate. It's how the United States Supreme Court has interpreted that word in a series of United States Supreme Court decisions starting in 1982. So it's not everything that a parent wants for their child. IEPs should be robust. The goal should be ambitious. There should be what's called meaningful educational progress, not trivial progress. Those are words from the various Supreme Court decisions, the Rowley decision, the Andrew F. decision, and there are many other decisions out there. When a student is not receiving a free appropriate public education and they contact me, the very first thing I do is listen to the parents. The next thing I do is try to read along with the parents believe based upon the documentation, IEP, evaluation reports, progress reports, report cards, emails, wherever that documentation is coming from, to see how I can determine when, where, why, if at all, the wheels went off the track. If you make the case that there's a denial of a free appropriate public education, for me as an attorney, I don't know if Jane or Allie have different perspective, it's always advisable to have some kind of evaluation report, an objective set of data that is that's supporting the parents' belief there's a denial of a free, appropriate public education. Now, the federal law requires placements to be in what's called the least restrictive environment, sometimes referred to as the LRE. Because this is a civil rights law, Congress created in 1975 a right for children with disabilities to be educated in public schools alongside children without disabilities to the maximum extent appropriate. If they're not receiving appropriate instruction, there's no meaningful progress, worse, there's regression of skills over time, that's when you start making the case for an out-of-district placement. Some school districts are more than willing to consider that placement, and there are some districts that are, our public school is perfectly, fine to meet the needs and provide a free, appropriate public education in the least restrictive environment. So that's where independent evaluations sometimes come into play. That's where private evaluations come into play. That's where requests for due process hearings come into play. When a parent truly believes their child is being denied a free, appropriate public education, the public school is no longer meeting the child's needs, and they think a private special ed school has all the services, the staff, the methodology in place, and the structure and support where their child can be, properly educated. As I mentioned before, some school districts are more than willing to consider such a request. Often school districts are denying those requests because they believe they have an appropriate program. Often these private special ed schools cost considerably more in the form of tuition, transportation, other direct and indirect costs. So from my perspective, it's always important to well document your concerns, agree where you can agree, document the areas of disagreement, get letters or evaluation reports that support your belief as a parent that your child is not receiving a free, appropriate public education. And that's where those procedural safeguards that I mentioned, those are the parent and students' rights. And it's important to consult with an advocate. It's important to consult with qualified professionals. It's important to consult with an attorney step by step before launching a request for an out-of-district placement. You need to have the data to support your wisdom and your intuition and your experience as parents. And sometimes that's enough. Most of the time, in my experience, you need a lot more, like independent evaluation, private psychological, speech and language, occupational therapy, wherever the dispute is, you need to have that, as parents, you need to be supported by others.
The other thing I'd like to say too is that each school is that they might have a different area of expertise. So your child might not have the profile appropriate or for some schools to support. So you might have friends that have a child in a certain school that you'd wish your child to also participate in, but they do look at the profile of your student when deciding if it's an appropriate placement. So just because you would wish your child to attend X school, that school might not deem your child for them to be able to support your child appropriately within their setting. The other thing to remember too, that when you choose to do an out-of-district placement, there are some things that you are going to experience that will be different to being in your community setting and your community school, potentially, if you're having to travel a distance. Your child might be on a bus and traveling backwards and forwards for a longer period of the day. So that needs to be taken into consideration. You also need to consider that it might be more difficult for you as a family and as a parent to connect and socially engage with the participants at that school if you are working and social events and activities are going to take place in a different town, that your child might then find it difficult to participate in a local sports team if transportation and things like that make things more challenging. So there's other elements to consider when you are considering out-of-district placements. Your child might not have access to neurotypical peers as frequently or readily during the day or a week to develop those peer role models and things like that. So there are other things to consider. An out-of-district placement, there might not be available at the time that you might need it. There might be a waiting period for a place to be available in a specific school as well. So it isn't always the silver bullet, and it isn't always guaranteed. Even if you do find a school that you think that you would like, that might not necessarily always be the right fit.
Just
We
want
had
to
a quick question about a child taking the SAT. In Connecticut, the State Department of Education uses the SAT as a measure of progress for high school students. So the answer is yes, unless they qualify for an alternative form of assessment. The Federal Department of Education is very strict on not exempting students with disabilities from statewide testing, such as the SAT. And I think it's either 1 or 2% of the student population which is discretionary, may be exempt from taking the SAT. So I would take the SAT if you're worried about colleges. Many colleges do not place too much emphasis on the SAT score. They're looking for other information. I also we were talking about summer programming. We received a bunch of questions prior to the webinar about summer camp for children with disabilities. Jane or Allie, do you have any suggestions or referrals?
I think my suggestion would be to look at your local community. Quite often recreational departments, towns or cities might provide some kind of summer camp programming. JCCs, I know that we do in the Stamford JCC, we do have a summer camp program called Hand in Hand for children ages 3 through to 9th grade, but it might not always be an appropriate setting for your child. You would know best as a parent and as a family. YMCAs typically offer some recreational programs and camps over the summer. So really, I suggest that you look at your local community and talk to other friends. I know that there's some social groups online on social media where parents confer and share experiences in different camps. But I would start there. It depends upon your family's budget and your family's logistics and the nature of your child, maybe your child's preferences. If there's a particular thing that they're interested in, you might want to find a camp that can promote that interest or spend time with other students within a similar area of interest. So the answer is there's lots of choices out there. What's right for your child is a very personal thing. And what you wish your child to engage in, again, is a personal family decision based upon a variety of factors.
And also, I would suggest, Jane, and adding to your list would be the state of Connecticut's website on special education has a list of camps and summer programs according to what your child needs. And it's listed about, in categories. So that could be helpful as well. CPAC, Connecticut Parent Advocacy Center, is also a really good resource to check with, because they also have quite a bit of experience, as well as the resources to provide you with different camp and activity programs.
And I would just add one more, to ask the local school district. Maybe they have resources that we haven't thought of, because they have other children going to summer programming nearby. So in effect, pound the electronic pavement to find those resources. There are resources out there on the various websites and the referrals that were mentioned by Jane and Allie.
I was going to say to you,
excuse me, the Connecticut Family Support Network. That's another resource. I forgot to mention that. The Connecticut Family Support Network has a guide or a camp database, and just Google Connecticut Family Support Network and look at their summer camp database, and you'll get another set of resources.
The challenge is a lot of camps, it's very hard for the camps to staff their programs with adults or specialists that have maybe this skill set that your child might need to support them over a prolonged period of time over the summer. So just take that into consideration too. In some instances, you can, depending upon where your child is at and what your child's needs are, you could potentially have a conversation with the district about together finding an appropriate program and seeing where that would take you. But it's such a unique conversation. There isn't a one glove fits all with the summer months, unfortunately.
Oftentimes, your community has a camp for typical students, and if your child has a special need, it's very appropriate to ask at a PPT if your child can be supported by an adult or an assistant that has a certain skill set or a certain type of support system that would be beneficial to your child. So if your child is able to participate in typical activities but needs the support, you can ask your school through the PPT for that support. And oftentimes schools will provide, because it is part of the child's educational needs. So it's, can also be under compensatory education as well, as we were talking, because it depends on, if your child had, let's say, social skills and was not provided that services during the year, then maybe the camp program can be part of that compensatory service. So you have to be creative, but I would also look into your community local camps as well.
We had a question come in prior to the webinar about an inaccessible playground. And this has been a source of contention for me and many of my clients over the course of my career. Section 504 was enacted in 1973. The Americans with Disabilities Act was enacted in 1990. Both laws require playgrounds to be accessible and usable to children with disabilities. And one would think by the time 2024 has rolled around, with these laws been on the books since 1973 and 1990, that this should not be an issue today. If you're dealing with a school or a public park playground that's inaccessible and it's been renovated or installed sometime after 1980, that's when the 504 regulations were enacted, or sometimes after 1992 when the ADA regulations were enacted, you have a right to file an OCR complaint. That stands for Office of Civil Rights with the United States Department of Education. Or here in Connecticut, on occasion, our U.S. Attorney, United States Attorney, which is part of the Department of Justice, will investigate those claims of inaccessible public facilities such as a playground.
Working with the school, I know the physical therapist within the school or the school district does an accessibility assessment at whatever playground your student is, whatever elementary school or middle school. So I think I mentioned that before, that during the summer, an accessibility assessment can be done. And the physical therapist can really look at your child individually and see what the playground needs to meet your child's needs. So, I would certainly recommend looking into that. If you feel that there are, that the playground has some benefits, but doesn't have others that are specific to your child, then the physical therapist within the school district should be able to conduct that accessibility assessment and give you what you need and make it happen. That's a reasonable request to make.
Just to extend from that, if there's a visual impairment, BESB is also an organisation in the state that would come out and work with the district to ensure that the space was a safe and appropriate location for somebody with visual needs as well. So there's different state agencies that have specialist expertise that would collaborate and work with the district to help them ensure that their space was suitable for students too.
We had a question come in about testing of a student with possibly an intellectual disability and whether a parent can refuse or decline cognitive or IQ testing. What you have to understand, at least in Connecticut and some nearby states, there are state agencies that serve young adults with intellectual disabilities, autism, and other categories of eligibility. And if you have, in Connecticut, our Department of Developmental Services, that's the state agency that provides services to people with autism, looks at cognitive scores that are obtained prior to age 18. So it's very important that if you're thinking about the possibility or the likelihood that your child as a young adult will need services from adult service provider agencies that serve people with intellectual disabilities, you want to make sure that you have a clear record that you can take to that state agency establishing that your child meets the statutory definition of an intellectual disability. In Connecticut, that means IQ scores of general intellectual functioning below 69 and adaptive behavior scores that are low. And the young adult is a resident of Connecticut. Our state law looks at an intellectual disability originating prior to age 18. So ordinarily I would not decline testing because the Department of Developmental Services is going to look at all evaluations and the more recent evaluations that you have establishing an intellectual disability, the better.
Just to add to that, if you feel that the school is not the right agent to conduct the testing, you have the right to decline the school, but you can also get your own independent evaluation, intellectual evaluation. So if you're coming from that sense of mistrust or you're feeling uncomfortable with the school doing it, you're certainly able to have your own evaluation done independently.
I saw that there was a question that we were asked during this webinar, how can somebody find out who is an attorney or an advocate practicing in the state of Connecticut? There are different organizations that provide lists of advocates and attorneys within the state. The Special Education Legal Fund is one organization. The Council of Parents, Advocates and Attorneys might also provide you with a list. You can also go on social media platforms and ask other parents or who they might have used through recommendations. But there are different organizations that you can find out who are advocates or attorneys within the state of Connecticut. And the question also said, what certification do you have to have as an attorney? Well, Lawrence can vouch for the fact that to be an attorney, you have to go to law school, Lawrence. If you have anything else to expand upon how we would
pass a bar exam, which is equally torturous as going to law school. And you have to have experience. People ask me, where did you get your experience? This wasn't available when I was a student in law school. Some law schools actually have courses on special ed law, disability law, but when I was in law school, there was no such courses. How did I acquire my training and experience? I worked for a state civil rights agency that advocated for the rights of people with disabilities. I would go to national conferences. I would go to regional conferences. I would listen to more experienced people who've been advocating for the rights of people with disabilities, including Judy Heumann, who passed away just about a year ago. And you become inspired by people who have been fighting the fight, advocating for the rights before I started my career at the State Protection and Advocacy Office. That's what it was called back then. So, and then talking to other people, other lawyers, other advocates, certainly the best source of training and information for me are my clients. Just when I think I know everything, there's something brand new. And the consistency of research on my part, understanding, and today, I think Allie or Jane used the word complexity. Students have become far more complex today. I don't know if it's today versus years ago, but the issues that are affecting us, the level of anxiety that permeates our society, are creating new found opportunities for me to learn skills I didn't even think I needed to learn. So it's the process of doing these cases, listening to parents, litigating, negotiating, reading, going to conferences that helped me acquire the skills that I have acquired. I like to say I've been doing this for more than 25 years, but my daughter wants me to feel old. I've been doing this for 40 years. And I enjoy each and every day because each day is exciting and it's a challenge. And I myself, and I know Jane and Allie, we try to make a difference in the lives of the people we represent to make things better, to obtain that free, appropriate public education, to obtain that service, to get those evaluations, to try to get the questions, the hard questions answered. The easy ones are easy, but it's the hard questions, especially when we're dealing with the level of anxiety, staffing shortages, the complexity of a society that we're living in right now for multiple reasons.
So unlike an attorney, an advocate does not need a license. There is no license for an advocate. Whether that's good, bad, or different, that's the reality. So many clients, I ask, how did you find me? And a lot of it's word of mouth. A lot of it's just through networking with other parents, websites. But there are many different advocates with different experiences. Some advocates are advocates because they've had personal situations in their own family life, their own children or grandchildren, whatever, had special needs, and they have an affinity towards advocacy, and they go into that. Other advocates, like myself, have been in special ed all their adult life, and again have that desire and that yearning to continue in that path. Many advocates go into advocacy for different reasons. So you would have to really research, ask questions. That's your prerogative to ask questions, and interview advocates to see if there is a match, because there is no certification, but experience and their level of knowledge and their understanding of special ed and 504 and all of their background understanding is what goes into their skill in advocacy. And as a parent, you would want to know that before you choose an advocate. What is their background and experience? So there's a lot of different advocates out there, and that's your option to figure out which ones would match your needs.
And in the state of Connecticut, as an advocate, we are not required to have any certification or licensing. However, there are some very good organizations, such as the Council of Parents, Advocates and Attorneys, that provides formal instructional training that is over the course of 12 months. I completed it myself. And then to complete the training, I had to do practicum hours. I actually completed mine with Lawrence. So there are some very good organizations out there that want to ensure that advocates specifically are provided with the understanding of the federal guidelines and laws that surround special education and the IDEA. There's an organization called Rights Law as well. So there are different places that advocates can go to receive formal instruction from people that have tremendous amount of experience and expertise in different areas of advocacy. And that when it comes to special education law, there are some niches that some advocates prefer to support than others as well. So it's just finding the right fit. Interestingly enough, I was at a conference last week, and the other thing to remember about special education, and this came up quite often, is that when we're looking at special education and special education teachers, we have to remember that they're not all taught how to teach. So an example being reading. So you might assume that a teacher knows how to teach a child how to read, but that isn't necessarily the case. So of course, when you're at your PPT meetings, if your child needs specific reading instruction, ask questions about specialists within your district, for example, for reading or literacy. Don't assume that because you have a teacher across the table that teacher might be the best individual to teach your child how to read, or that teacher has the best understanding as to the best reading program. So just because somebody has a title doesn't mean that they have the specialty within that area to educate or to teach.
I have one of the questions that came in about assistive technology devices. In order to provide any service in an IEP, typically the school districts will do an evaluation, and there are assistive technology evaluations. That's a device or a service that is designed to assist the student achieve the free, appropriate public education. There's no one size fits all. It has to be uniquely tailored to the child's needs. So if you see the school trialing various devices, apps, hardware, software, and they're working, then they probably hit the nail on the head. But if it's not working, then I'm sure if I mentioned 100 apps, there are 100 more that I didn't mention. So if you have a concern with the assistive technology portion of the IEP, or there's no assistive technology in the IEP, ask for an evaluation. And this is one of the evaluations that you can request for as an independent evaluation if you disagree with the school's evaluation. Typically, the assistive technology people that I deal with from a school district are often occupational therapists and others who are trained in assistive technology. So I don't have any specific apps or technology, hardware or software. It's whatever helps the student. If they have communication difficulties, they have learning, writing difficulties, whatever the area of weakness, that the technology can support the student to demonstrate mastery or ability rather than disability. I don't know, Allie or Jane have some comments on assistive technology.
There's also through the foundation that I work with, there's also Star Inc. located in Norwalk. They now have a tech lending library where they will do evaluations for your child or young adult, even or adult. And the tech isn't just limited to communication devices. Tech can also include means of ambulation and mobility that need to be modified and tech provided. And the amount of tech that can be provided and is available to some students today is absolutely mind-boggling. I have a young student who is in kindergarten, and they are learning to and trialing a different type of wheelchair that they navigate with their eye gaze. It's trial and error, and quite often, because these pieces of equipment are extremely expensive, that it does take time to trial the devices and to get them improved by insurance. So the other thing with tech is you do sometimes have to be patient to navigate and find the right piece of equipment. And often the school districts, depending upon how specialized that piece of equipment is, it might take them a bit of time to find the right outside vendor, if you like, to collaborate and work with. But the technology that is available in some instances is quite remarkable, but it's very bespoke and depends upon the individual child and how they're going to connect and relate to it. And then it comes down to the training, not just of the child, but the adults using that technology. And we really need to have patience. And quite often the expectation might be, if we're just introducing, for example, a communication device, that we need to spend a lot of time using it to model before we place the expectation of the child to begin using it for their own modes of communication. So assistive tech can be very complicated and can take a number of different agencies collaborating together with a district, depending upon what the need is.
The only thing I would add to that is if your child has very specific needs that are outside of the typical assistive technology network. For example, if your student has high-level autism and is not verbal, you may need what we call an augmentative assistive technology evaluation, which is a different level of what may be an AT or assistive technology consultant that works in the district can do. So you would have to get to a different type or a higher level of evaluation. So, know what you're asking for. If your district can't do it, there's certainly, the Connecticut has different agencies that, work within the state that will send these experts to the school to do the evaluation. So, think about what your child's needs are and where to go from there. But sometimes the AT person within your school may not have the level of expertise that you may need.
Yeah, just to add to Allie's comment, some of our universities have departments, for example, at Southern Connecticut State University, I think it's in the School of Education, they have resources available to do evaluations if the students' needs are more complex than what can be handled in the school district. One final question, we're almost at the end of our allotted time. The question came in, can a school take away a child's IEP? And the answer is yes. However, before we get to yes, there should be an evaluation. Usually schools do evaluations to offer an IEP, and the federal law requires a comprehensive evaluation in order to exit a child from an IEP. In other words, removing the IEP. I don't know if Allie and Jen, you have different experience or comments?
I agree with that. There should be an evaluation before any exit of special education. I've also had the situation where a service provider, let's just say an OT, an occupational therapist, will say, oh, well, so-and-so has met all his goals and objectives. We're going to exit him from OT, occupational therapy. And I go, whoa, whoa. Just because he met all of his goals and objectives doesn't mean there aren't more goals and objectives that he or she needs, okay? So, there's a continuum there, you don't stop there. So again, we ask for an evaluation. Let's have an OT evaluation to see where we are, looking at, testing scores. But you really have to be cautious about mastering those goals and objectives, because that can be somewhat subjective rather than objective. So just be cautious about that.
Yeah, and it could be that if everybody's in agreement based upon evaluations that the child no longer needs direct services provided by an OT, but there might still be a need for consult from an OT just to keep everybody abreast of strategies or whatever. So that again, it's not a yes or no answer. There's lots of different ways in which this might be graded and bespoke based upon your child and where your child is currently performing.
Well, we've reached the end of our allotted time. We extended it a little bit this evening. I especially want to thank Allie for taking time out of her busy schedule, and Jane as well, to go through 8:30. We usually adjourn around 8 o'clock. I want to thank everybody who's joined us this evening, those that are still logged on. We will have another Zoom webinar. I believe it's on May 1st at 7 p.m. With John Savita and Tabitha Mancini, who are transition personnel coordinators from the Winston Preparatory School. And they are going to address supporting students with learning differences in a college and envisioning a life beyond. And so in Connecticut, we start transition planning at age 14. So it's never too early to start thinking about your child's life after they either graduate from high school in a traditional 4 years, or by the time they turn age 22, if they require more services. And if you have questions about transition planning, particularly in the college arena, we welcome your questions for the next webinar, which I mentioned was May 1st at 7 p.m. We have a YouTube channel for the Law Office of Lawrence Berliner for previous webinar recordings. This one will be placed on that channel as well. Jane and I will continue to monitor developments in the field of education. Our General Assembly just convened last month. There's not much legislation that's coming out of the General Assembly, but if there is, we will keep an eye on that, as well as whatever developments are down in Washington in Congress. I want to thank Allie Grafman and Jane for their collaborative efforts, insightful thoughts and comments. I also want to thank my daughter, Rachel, who's off camera to my immediate right, because without her tremendous efforts to put all of this together, to be in touch with those who are registering, setting up all the technology, she's my assistive technology person. We could not put these webinars together without her. So those are my concluding remarks, and I know Jane and Allie would like to offer their concluding remarks as well.
I'd like to thank Allie for joining us again tonight. I think it's been a very informative conversation. This is an extremely stressful time of year for parents as we begin to plan for the summer ESY, as well as for the upcoming school year, and try and reflect back on the performances that we've had to date. I'd also like to thank Rachel and also Debbie, who is Lawrence's wife, who without her as well, these webinars would not be possible. So thank you to the team behind the camera. And Allie, we look forward to having you back soon. No doubt to engage in lots more conversation. In the meantime, please enjoy the spring. Hopefully the weather will start to be consistently warmer, and we look forward to seeing you on May the 1st.
Thank you, everybody, for joining us tonight.
Happy holidays. We have many holidays and vacations next month, so we wish you, good tidings for the holidays. Thank you.